Larke and Nugus is a commonly used phrase, but not a lot of people are aware of what it actually means. And Larke and Nugus was actually a case from round about the turn of the century 2000, which determined the law on requests for information regarding circumstances surrounding the instructions given for a will and the execution of a will. In the case itself, the validity of a will was challenged on the grounds of undue influence. Information relating to the will's preparation was requested by one of the disappointed beneficiaries, and it was requested on numerous occasions to the will writer. The will writer refused to provide this information to the disappointed beneficiary on the basis that he had a duty of confidentiality. This duty of confidentiality was between himself and the testator during their lifetime, and upon their death then passed to the executors, and so he had no reason to provide any information to this disappointed beneficiary. And so the disappointed beneficiary was left with having to make a formal claim against the estate via the route of the court, challenging the validity of the will. What transpired was, had information surrounding the signing of the will and execution of the will being provided, they would not have had any grounds to make such an application. And as a result, they would not have needed any court action. And within the case, what they said was, if the testator is dead, the solicitor must not disclose any information before probate is granted, except to the executors, without their consent. So they said you still must have the executor's authority to release information. However, this doesn't necessarily apply if a solicitor is asked to disclose information surrounding a will which they have prepared and which is in dispute.